Hi, everybody. Thank you for joining us again today. This is Jennifer from Weinberger Divorce and Family Law Group. We're so happy to have you with us. In today's webinar, we're going to talk about low conflict divorce in New Jersey and how you can go about getting one of those low conflict divorces for you. It can be done, and usually that's done by filing for divorce based on what we call irreconcilable differences. We're going to talk about what that means and how you can file for your divorce right here in the Garden State. Perhaps you've wondered how you can go about getting a divorce with at least muss and fuss as possible, of course, with as little stress and as little money out of your pocket. So that's what we're going to talk about today. First, our disclaimer, we're going to let you know that this presentation does contain general information. It does not constitute legal advice. Please be sure to direct any specific questions about your own situation to a family law attorney. And talk to us. Give us a thumbs up when you find this information useful. We're live right now, so if you want, you are certainly welcome to ask me a question while we're going along. So this way I can answer you in real time. If you're more comfortable having more of a direct communication or conversation, please let me know by sending me a direct message here on Facebook, and we'll do our best to answer you as soon as we're done here. So I'm monitoring as we're going along. So again, if you have a question, please feel free to answer. So filing for divorce based upon irreconcilable differences here in New Jersey. So let's get started. What are we going to cover today? Well, we're going to talk about the grounds for divorce here in New Jersey. What does that mean? What are grounds for divorce? That might be a common term that you've heard, but you don't really know what exactly grounds for divorce means. And then we're going to tell you how to file for divorce based upon irreconcilable differences, which we believe and we tell our clients is probably the easiest path to getting divorce, if there is such a thing as an easy path. At the end, hopefully we'll have time for some questions, and we're going to give you some information on where you can find additional information. So part one, what are the grounds for divorce here in New Jersey? Well, grounds for divorce, just to define it simply for you, are the reasons why you want to file for a divorce here in New Jersey. The judge needs to know why it is you want the court to end your marriage. And some of the grounds or reasons why couples want a divorce include adultery, they can include extreme cruelty, and they also can include irreconcilable differences. Irreconcilable differences is one of the several grounds in New Jersey that you can choose, but it is the easiest, the most common, and absolutely the least stressful grounds that you could file based on here in New Jersey in order to get your divorce. So in order to file for divorce based on irreconcilable differences, what is needed? Well, you and your spouse must have lived in New Jersey for 12 consecutive months before filing your complaint for divorce. We lawyers call this establishing jurisdiction. So New Jersey has to have jurisdiction over you and your spouse before you can file for divorce. Otherwise, New Jersey will say, well, you haven't lived here for 5 years. Why should we be the state who hears the case? Now, what's really important is the consecutive months. It's not 12 months total, it's 12 months consecutively. So don't, live here for 10 months and then move, and then come back and think, well, I only have to live here for 2 months in order to be able to file. That's not true. So don't break your jurisdiction there. Make sure it's 12 consecutive months. You also must have had experienced the irreconcilable differences or the problems in your marriage for at least 6 months before filing. So you can't have been experiencing irreconcilable differences for 2 weeks and then file for divorce based on irreconcilable differences. Now, everybody says when we let clients know this, they all say, well, it's been years. it's at least 6 months. So if it's been 6 years, we're sorry, you've been experiencing these problems, but it's not max 6 months, it's at least 6 months. The problems or the differences that you're both having leads you to believe the marriage should be dissolved and that there's no reasonable prospect or belief that you can reconcile. So, you both have come to the conclusion, or at least whoever is filing has come to the conclusion, that these irreconcilable differences caused the breakdown of the marriage and have led you to the court to ask the court to dissolve your marriage. A little bit more about irreconcilable differences. What irreconcilable differences is really a no-fault divorce. You've probably heard that term. No fault meaning you don't have to tell the court any wrongdoing that either of you did to the other. Now, no-fault divorce or irreconcilable differences divorce hasn't been in New Jersey forever. There was a time, really not very long ago, where you would have to describe fault because there were no grounds for irreconcilable differences. So, unless you were filing based on being separated for 18 months or more, and a lot of people didn't want to wait the 18 months, they would choose to file based on, say, extreme cruelty. And if you do file based on extreme cruelty, it's still available, but you have to describe several incidents in your marriage where your spouse has done something wrong or been extremely cruel to you. And that can lead to stress, it can lead to anxiety. You're putting out in a really a public record details about your marriage that you may not want out there. So this way you don't have to talk about specific instances of wrongdoing. You just have to say, listen, it hasn't worked out. It's been at least 6 months. We're not going to get back together. Less stress and anxiety is great for the entire family, including your children, because as I'm sure you know, if you have kids, they understand when there's fighting in the house or tension or hostility. So really this path of least resistance is best for your entire family. Part two, the practicalities here. How do you file for divorce based upon irreconcilable differences? Well, your first step is you want to complete and file your complaint for divorce. Now, the complaint for divorce contains your marriage basics, the date of your marriage, when and where you were married, your addresses, really basic identifying stuff. Also in the complaint, you're going to tell the court that you have experienced your differences, again, for at least 6 months, that they lead you to believe your marriage should end, and that you have no real belief that the two of you can work it out and reconcile your marriage. If it applies to you, in the complaint, you're also going to include your requests for spousal support or child support if you have children, any requests for custody, parenting time, division of property or debt, anything that you need the court to decide for you in order to divide the marriage fairly and equitably, you would want to include in this first round of paperwork. Now, you want to make sure you complete all the paperwork with your complaint. It's not just a complaint, there's accompanying documents that go with it. You can find the entire packet at your local courthouse. They'll be happy to give you the packet, or you can download it from New Jersey courts online. Other documents that you will see need to be attached include your affidavit of insurance, which lets the court know what types of insurance you have and policy numbers and things like that, as well as the confidential litigant information statement. Now, be sure to complete all the necessary forms. And to be honest with you, it can get overwhelming. If you feel as though you're becoming overwhelmed with the amount of information that you need to complete, or the number of forms that you need to complete, or you're just not understanding the steps, consult with an attorney. The attorney is more familiar with the forms. They've looked at them a million times. They can certainly help you. So again, if you're feeling as though you're just completely overwhelmed by the process, talk with a family law attorney who's experienced in divorce and handling these types of matters. Once everything is compiled and you've completed the complaint, got all your documents together, you're going to file them with the court. and you have to file them with the court before you can give them to your spouse. The court's going to give you back a stamped filed copy, meaning the divorce has officially been assigned and filed. So once that happens, your spouse is legally entitled to proper service of process. Your spouse must get all copies of all documents you file, except for the confidential litigant information sheet. We talked about that briefly earlier. Please know that simply mailing the papers to your spouse or leaving them in the house if you're still living together is not proper service. Unless they formally waive their right to service of process, your spouse must be served in person by either a professional process server or by your local sheriff. If you don't do this properly, your divorce cannot proceed. Now, again, your spouse can waive that, but they would need to sign an affidavit that they're waiving their right, and you would need to file that with the court. Again, just mailing it is not going to be good enough. If you don't provide proof to the court that you served your spouse properly or that they waived it, your divorce is not going to go forward until that happens. Now, the next step is you have to wait for your spouse to respond if they're going to. Once they are served properly, you're going to file that proof of service with the court. If you use, say, a lawyer service, they will give you the document that says on this date and on this time I served this person, and you're going to give a copy of that to the court. From that point, your spouse has 35 days to respond. Now, in their response, they may deny that you're having irreconcilable differences. Perhaps your spouse doesn't want to get divorced. They may say, no, we're not having any problems. Your spouse may counterclaim for other things that you didn't put in your divorce complaint. Perhaps you didn't talk about parenting time. You've asked for custody, but you didn't talk about parenting time for your spouse. They may counterclaim and say, I understand the divorce has been filed, but, I need to be heard, Your Honor, about parenting time. So I'm counterclaiming for that issue. If your spouse does not respond, you may receive a default judgment. That's where you go to the court and say, listen, Judge, 35 days has gone by. I've gotten no response. Let's proceed, even though you have no response. It's very important to know, and this is a question that comes up a lot. What if my husband or what if my wife doesn't agree and says they won't give me a divorce? You don't need your spouse's permission to be divorced here in New Jersey. The only thing you need, which is why I really focused on it last slide, is you need to show that your spouse was served properly and given the opportunity to respond. You don't need their permission. So don't get hung up on a spouse telling you that they're not going to give you a divorce. It's just not necessary here in New Jersey. All right, once both of you have filed all your paperwork, the court process, including discovery, begins. Now, again, this is assuming that your spouse has responded. If not, as I said last slide, the divorce will proceed as a default. But if you've both filed paperwork, the court process starts and discovery begins. Discovery is that formal time when both of you are exchanging information regarding property, appraisals, expert reports if you're fighting over custody. That starts once all the paperwork has been filed and sent. Cases with no issues obviously move faster. If you have no children, if it's fairly short-term marriage, if you're not asking for alimony, with no issues, obviously they will move more quickly through the process. Now, most cases, really the vast majority of cases, settle at or before the early settlement panel. What's the early settlement panel? Well, the court is going to give you and your spouse many opportunities to work it out. And the early settlement panel is one of those opportunities. It's sort of like a formalized mediation where you and your spouse sit down with your attorneys, and with the help of a local attorney who volunteers their time, you'll attempt to arrive at a settlement. And that comes, a few months into the process. But, again, I think it's something like 90 to 95% of cases settle either at that early settlement panel or before. there's just no way that any court in New Jersey could try every single divorce case, have a trial. Cases would take 10 years. So again, courts really favor settlement. They favor mediation, negotiation, and you and your spouse to work it out. Now, once you're all settled and you have an agreement, you want to put that agreement on the record. That's going to happen at your final hearing. The judge will pronounce you divorced. They will enter a final judgment of divorce. Your settlement agreement, hopefully you two were able to work it out, will become part of your final judgment of divorce. And that's it. The formality is over. You will receive your final judgment, and you can proceed with changing your name or, however it is you wish to proceed after that. Again, always consider those alternate dispute resolutions. Negotiate before you file if you can. If you and your spouse are in a good place and you can sit down, attempt to work out what's important to you prior to even filing for divorce, because again, this is going to make things run much more smoothly if you have no or very few issues that you need to bring either to mediator or to the court. Consider mediation or collaborative divorce. Mediation is a process much like early settlement panel, but you and your husband or wife would enlist the services of a professionally trained mediator. Here in New Jersey, you would sit down, both of you, with the mediator and attempt to come up with a plan that the both of you can live with and that the both of you can move forward with as you go into your new futures and new lives as divorced. So always consider that. Collaborative divorce is a fairly new phenomenon here in New Jersey. Lawyers are becoming trained in the collaborative divorce method. You and your spouse would agree with the assistance of your attorneys to work it out through this process and not use the courtroom, not go to trial, not use a judge to determine the issues in your divorce. So this is another way where couples are figuring out how to work it out themselves and come up with their own property settlement agreements or marital settlement agreements. I have a little note here that you do not receive more for your spouse's bad behavior. What does that mean? Well, we go back to some feeling that, well, perhaps your spouse cheated on you. And while that's horrible and it's a devastating process to go through, the court is not going to award you more of the marital property or give you the marital house simply because your spouse cheated on you. The court here in New Jersey looks at a marriage as a business, and they want to know who brought what to the business, what was made during the marriage, and how to fairly divide it. We are not an equal property state. We are an equitable division state. Equitable means fair. It doesn't always mean 50-50. It could, but it doesn't necessarily mean split everything 50-50. So, don't adopt a all or nothing or I'm going to make you pay attitude for bad behavior in the marriage, because that's not how the court's going to look at it. And all it is going to do is drag out the process of the divorce, increase your stress level, increase your anxiety, and increase your legal bills. That's it for today. Don't forget to subscribe to our Facebook events tab to be notified about our upcoming live webinars. You can see the link there. And there's our contact information. If you'd like to give us a call, you see our toll-free number there is 888-888-0919. Give us a call to schedule your free and confidential consultation with us. You can also visit us online at weinbergerlawgroup.com. There you'll find a lot of information, not just about divorce, but about domestic violence, custody, adoption, really any area of family law that you need a little bit more information about.